Good morning, all. Welcome back to the Rhine Report. This is Stuart Rhine, and I'm here today with an update on my headline, which is Ninth Circuit stay of Judge Immergut order to block troops from deploying to Portland. The update is that yesterday there was a 3-panel hearing in the Ninth Circuit Court of Appeals, and a MAGA fascist judge named Nelson, +1 I believe, will absolutely crush the Immergut ruling disallowing the Trump's intercession and deployment of federalized troops to Portland. Now, Nelson, this fascist moron and extremely ignorant creep of a judge, asked the absolutely ridiculous but illuminating question of counsel, and I quote, "I don't get it. Why can't the president do what he wants to do with his resources?" Have you ever heard anything so stupid from a Court of Appeal jurist? It was a rather coarse, moronic attempt to endorse unconstitutional executive power and mouth a vague, thinly veiled defense of Trump's right to judicial deference over the rule of law that they're there to consider, which was 10 U.S.C. 124.06. Well, this schmuck forgets that we do have laws and a constitution, and the Trump regime must abide by them, just as we all must do. Has Nelson ever read a picture book, let alone the Constitution and the federal law? How is this cretin sitting on a court of appeals? The level and the direction of this oral argument and discussion from the court was of a standard so low, meaningless, and in absolute disregard for the law and the lower court fact-finding, that I would not permit these judges to be allowed to shine shoes or even pretend to be dog walkers. But Nelson's illiterate and undistinguished questioning served as an imbecilic tell, so we know the result here before it's even being written. The worst of them, Nelson, a Trump appointee, said courts should not engage in, and I'm quoting here from him, a day-to-day review of whether troops were needed at any given time, meaning if there was once trouble, then Trump is now justified in deploying troops when the streets are calm and peaceful. How fucked up is that? It's preposterous. And of course, we had to endure their continuous line of questioning, completely skirting the issues of differentiating and distinguishing earnest, peaceful protest from actions that actually prevented the president from possibly executing the laws. It revealed their absence both of knowledge and an understanding of the First Amendment rights to freedom of assembly and free speech that we as a people cherish, as well as lacking in sound judgment in their rush to justify deployment. What a disgrace to our judicial system And how the Ninth Circuit has come, to this low point in its collective life. These incompetent and biased judges, at least two of them, the Trump appointees, seem to outrageously question and repudiate the trial court's finding of fact in disregard of the actual record below and in disregard of the strict rules of deference accorded to a trial court's finding of fact, unless it is clearly erroneous. In attempting to justify Trump's argument that the deployment of troops was necessary to the non-existent extremist rioters and protesters, somehow preventing law enforcement with their automatic weapons from ensuring the laws are enforced and federal sites are protected. Where Judge Immergut had come to her conclusion as to the facts based on a development of the evidentiary record that this problem was absolutely not present to justify the Trump military intercession and therefore did not satisfy the third prong of 10 U.S.C. 12406, the only law that's in question here in terms of deciding whether or not the stay should stay enforced. And that's what the case rests on. Nelson, +1, could only argue or question the state counsel realistically on the third prong, though they tried hard to implicate or infer something of prong 2, which is, there must be a rebellion. What is a rebellion? Badgering her, asking for her to define the accepted meaning of rebellion, which she did rather well. Let's be absolutely fucking clear about this. Appellate courts typically show significant deference to the factual findings of lower courts and do not retry cases. This principle is a cornerstone of the appellate process right up to the Supreme Court, recognizing that the trial court is in the best position to assess witness credibility and evaluate evidence. The standard of review applied to factual findings is a high bar for overturning a lower court's decision. And as I had said, the clearly erroneous standard is the yardstick. Thus, the most common standard for reviewing a trial court's factual findings is the quote-unquote clearly erroneous standard. Under this standard, an appellate court will not set aside a finding of fact unless it is left with a definitive and firm conviction that a mistake has been committed. They can't divert into other issues, other cases, other factual circumstances such as the ones in California and rely on them. They can only rely on the record below. My answer to all of this is, it is incredible how bad it is. I believe the state should immediately file a motion or get an application in before it's too late to have an en banc hearing of this matter. Thank you. Let's get on with it.